Hi, this is Rahul Reddy live here from Houston, Texas. Every Tuesday at 5 p.m. Central Time, Reddy Neumann PC does bring in immigration updates. Along with me is my business partner, Emily Neumann. Emily, public charge rule, what's going on? Ping pong. Once it was, they introduced the I-944 and then said everybody has to file these things. Then the court comes and says, no, you don't have to file it in a certain place. And then it goes to the preliminary injunction, and they give a preliminary injunction that nobody need to file it. Then New York court comes and says, okay, you can file everywhere but except in New York, and now in Illinois, and went to circuit court, comes back. What's going on? Do we still need to file a 944, or are people still stuck by the public charge rule? What is going on?
Well, the USCIS has not updated its website in response to this court's decision, but officially the court in Illinois did vacate the entire rule. So everything that's happened up until this point was preliminary injunctions. Some of them were nationwide, some of them were limited to just to the jurisdiction where that court had authority over, and that's why we were seeing all this ping pong. Well, a preliminary injunction is preliminary. That means that it's blocking an action from happening while the court actually decides the case. The court had not actually made a decision in the case until yesterday. So now we actually got the decision of the court. They agreed that DHS did not have the authority to pass this regulation, and so they vacated it, meaning it's wiped out. The public charge regulation is no longer in play. So that means you should not have to file a 944 form. It means that you shouldn't have to answer those questions on the I-129 and I-539
So what do you mean, all
form.
these applications that we filed last month, income tax returns, W-2 forms, these credit scores for even kids they're asking for, are all went in vain, Emily?
Yes.
Now this is from a district court. In the U.S. we have a system, the federal district court we have, and then we have the circuit court, which is the higher court than that of the district court, and then we do have the Supreme Court. Now this is permanent injunction came from the district court. Doesn't USCIS has authority to go to the circuit court and get it reversed?
Yeah, absolutely.
And last time when they went with the preliminary injunction, which was an interim thing, it was Amy Barrett, which is a Supreme Court justice right now, who was in the circuit court, did reverse the entire thing. Now, can the USCIS not go on this permanent injunction?
Yeah, absolutely. They can appeal this decision, so it's in no way final yet. They've not given any indication of whether they intend to appeal the decision. I'm sure everything's waiting on election results at this point, but it could come back.
Emily, if you were to file an adjustment of status application right now, would you prepare the 944 and file it?
Until USCIS updates its website, I probably would.
Until I know certain that the USCIS is not going to appeal this court, I will file it. That's my opinion.
At least for typical employment-based applicants, because the 944 form for most high-skilled workers, they're being paid well. They're not really going to become a public charge, so it's really more of a formality. It's not like providing this documentation is going to cause them a denial. That's what we expect. Now, has anybody actually been adjudicated who filed with an I-944 form yet? No,
not yet.
Because that only started in February, and then that went back and forth during the whole COVID situation and restarted in October. So there's been so much back and forth with this, but because I don't see any negative impact to the client who's in the typical employment based, unless they've got like a bankruptcy or a zero credit score, I'm probably going to include it even if it's not mandatory yet, because I don't want that 485 to be rejected because we didn't include it. And the mailroom makes all kinds of errors like that, and if they weren't instructed, which USCIS still hasn't put out official guidance saying not to submit it, so I'm going to submit it until they say otherwise.
Emily, this administration for past 4 years have been changing the rules so frequently. I mean, In the past 25 years that I've been practicing, this past 4 years, I've seen so many changes that in the preceding 20 years before this administration, it's like 5 times. Forms changes every 4 months, things changes every 4 months. What are they trying to do? I mean, look at the H4 EAD, for example, which used to take about 4 months to get adjudicated. Most of them used to be adjudicated along with the premium processing of the H1B. Now it's taking 15 months to get adjudicated. The adjustment of status, which used to take about 8 to 12 months, it says 45 months to get adjudicated. Mm-hmm. This is ridiculous. What is going on in the administration?
Yeah, it's clearly overall kind of overarching theme of what can we do to slow this process down, to cause people to get so frustrated that they give up and go elsewhere. I really think, we've talked many times about this wall that Trump is building on our southern border, but he's building a virtual wall as well.
He already did.
Yeah, that one's built or in the process, but this is a different type of wall that's
the virtual wall is already built.
Yeah.
So if you look into the adjudication process of the EAD, when it was like the premium processing used to take 2 weeks to 3 weeks at the maximum, we used to get an EAD approval. Now it's 15 months. Think of this, if this administration is going to be back again, it's going to take about 42 months to get adjudicated for the H4 EAD, which they're not even eligible for, because by the time you get adjudicated, you don't need the EAD. What do you think of that?
Yeah, I mean, I think that's definitely their overall plan. There was an article recently that talked about what Stephen Miller's next plans were for immigration, and it's more restrictions, make it more difficult, all of this extreme vetting. It's just so cumbersome that no one's going to want to go through the process.
Emily, what are the more changes that at least that are in the pipeline, that have already been gone through the regulatory or the process, that people need to be aware of right now and be prepared for it?
Yeah, first is the prevailing wage changes. That's already in effect. It was done as an interim final rule. It does have a commenting period. It does have a lawsuit pending, but that took effect October 7th. So any LCAs or prevailing wage determinations after October 7th are going to be under the new prevailing wage calculations, which are greatly increased. There are so many problems with that regulation. Now that you look at the new the new wages, if you go to New York City, for example, and look up the wage for a natural sciences manager, there's no wage data in New York City. So that means that you're required to pay $208,000 a year, regardless of what your level is, 1, 2, 3, or 4. There's no levels. So you have to go and find a private survey for that. There are a total of about 18,000 different combinations of cities and jobs that have no wage data at all from the Labor Department.
Uh-oh.
So I think that was an unintended consequence of this, or maybe it was intended, who knows. But I think that is something that'll be very important to this preliminary injunction and upcoming litigation on that rule. So that's the first. Second, we have the new definition of specialty occupation. That will take effect from December 7th. It does not impact pending applications or already approved applications. It's only for H-1B petitions filed on or after December 7th. This makes the definition of specialty occupation more restrictive, so that you have to have your education tied exactly to the job duties and job title for your position. It shortens the approval period for those in third-party placement. So if you are at a client site and you're sponsored by another company, that client site is the third party. That means your third-party placement and your approvals are only going to be issued in 1-year increments instead of 3-year increments. And on top of that, they need all of the old Neufeld memo documents to prove employer-employee relationship and client letter, work order, vendor letter, all of that they want again, and this is in response to the IT Serve litigation that wiped out that memo. Now they're trying to bring it back through regulation. So that does have the commenting period going on, but it's also as an interim final rule to take effect December 7th. So if you have an extension coming up next year, you may want to consider filing before December 7th to avoid these changes. And then the most recent regulation, again impacting H-1B, is the change to the lottery. So for the CAP subject H-1Bs, last year was completely different. We have the electronic registration process. We get selected, and then we file the petition, and there's more time to file. If those cases are still pending right now, we have a second lottery round. We're still filing those. I think the deadline is November 14th. For the second round of the lottery, they want to wipe out the lottery completely and instead dole out the H-1B cap numbers based on your wage level. So wage level 4 petitions will be first selected, and then if there's still visas left over, they'll go down to level 3, and so on until they run out of the 85,000 visas. This again is a proposed regulation. It's not done as an interim final rule, so we do actually have an ongoing comment period right now, but if they proceed with it after the election, that's what we can look forward to for next year's lottery, is no lottery at all.
That's almost like the people who are in student visa will come under this new thing what you're telling. So if they are making a level 1 or level 2 though, if there are more level 4s and level 3s, these people are not going to get the H-1B lottery.
No chance at all.
So the lottery is not a lottery, it's whoever pays, whoever is offered more money.
Right. And to some extent it makes some sense if we want to, give the visas out to people that are, high skilled and all of that. But at the same time,
it didn't say the high skilled, Emily.
Right,
it's only highly paid.
Yeah, exactly. And there can be high skilled people that
so
maybe aren't highly paid.
For example, a lot of the researchers who work on these drugs and all those things, I mean, they are high skilled, but they're not highly paid.
Exactly.
So those get kicked out, but some people, whose demand is high right now because of the shortage of people, they will get it, but people like researchers and doctorates, those people will not get the H-1B based on this one.
Yeah, exactly.
But that's not how the H-1B was intended for, to, it should have been go through in the lottery system rather than the highest bidder here.
Yeah, and it is very open for fraud. I mean, what's stopping a company from giving an offer of $300,000 a year that they have no intention of actually employing the person come October at that pay rate? They just get the person, get the approval, and then that person transfers out to another company. Who's checking to see a year from now, is that person actually getting paid the $300,000 that they put in their registration? Nobody. So again, we are approving petitions, giving out H-1B visas without any kind of vetting, and then they come back later and do intent to revoke and revocations, and that's their fraud detection, is all after the fact, after they've wasted visa numbers on people that aren't actually eligible.
So let me summarize it and correct me, Emily. If these proposed regulations are going to be implemented, the next quota that we're going to be filing, starting from April 1st, everybody knows how the system is going to be filed. We will have to file in the lottery system the same way we used to file before, but the selection process will be based on whoever is getting more salary.
If you mean the lottery system, the electronic registration like we did this year, yes.
It'll be the same one.
So in that electronic registration, you'll specify what wage level.
So based on the wage level, then they're going to pick it up. And then, so if our wage level is 4, there's a good chance of picking up. If the wage level is 3, slight chance. Wage level is 2, very less chance.
Right.
Wage level is 1 is gone then, practically. So mostly that's the way it is going to be. But because I want all the people to be aware of it and want to plan around it, how they are going to do it, if they are going to be eligible for H-1B, if they are not going to be eligible for H-1B. Sometimes they may have to make choices. For example, if I get a job in New York, as compared to getting in Arkansas, some small place. The Arkansas, they may meet with a level 4, but not in New York. So that's a planning that I want people to be aware of. Maybe they should avoid the big cities, try to go to small, tiny cities. I remember that when I came into the United States, my wife got a job. We have to go in a place where the nearest McDonald's was about 70 miles. The nearest highway was 100 miles. So these people may want to pick a place where, if it's a remote job, for example, maybe they can go to such a remote desert area. Nobody stays there where the prevailing wage comes very low and they may meet the level 4, rather than staying in San Francisco or maybe San Diego or in New York area.
Potentially, yes, but then you also have to remember that especially these rural areas, they probably don't have the prevailing wage data like I was talking about earlier, which means you're at a $208,000 prevailing wage.
So yeah,
and
that's,
they haven't specified how that works. If there's no level 1 through 4, what do you put?
So they need to plan very early with regards to, hey, this is the town, which town should I go through? Maybe we need to educate ourselves on picking up some of the towns for these people where the prevailing wage, especially for most common software developer and all those things, will be there, and tell them to go to the remote village, the kind of village that I stayed for a year period in Texas, remote Texas. Emily, one thing on this level 1 and level 4, as we're discussing, is that in these new regulations, are you aware, will they accept the alternative wages? Is it going to be only level 4, level 3, level 2, or is it going to be the amount of salary that you pay?
In the lottery, it's only the OES, OFLC online wage library, the Department of Labor numbers. That you're not, they basically, you take your alternative wage survey and look at what that would be, what wage level that equates to. So if your survey has a lower wage, which that's, you know, the purpose.
You still have to meet the OES wage survey. Doesn't matter if the other alternative says it's level 4, but you're falling into level 2, then it's going to be level 2.
Yep.
Okay, I would advise all the people to probably, if you're planning to file in the lottery of the April of 2021, maybe you should try to see if you could, you know, look into your salary level, see where you meet it. If you don't meet it, what are the alternative plans that you can think where you can qualify? I would say that at least you should shoot for level 3. Otherwise, your chances are very bleak for you to get the lottery system. Any other updates, Emily, on the new laws?
I think that's it for today.
I just want to inform all the people that the appointments for the consulates are backlogged very much all over the world right now. You're looking at about March of 2021 to make an appointment, unless you qualify for an emergency appointment. Very less number of people are getting qualified for the emergency appointments. Another note that I would say is that the appointments, when they're given though, they're getting postponed. I remember that in April or May, when consulates started closing, they have given appointments in October, but then they said, no, it's canceled, you have to apply one more time. You may be hearing Trump saying that, well, we are open, I'm open for business and all those things. He didn't mean to say for immigrants though. I don't know whom he meant, but he closed up all the consulates and he's saying those words, so don't trust him on that particular thing. He closed the whole consulate except for the emergency things. We don't know if this March appointments will be open or will they cancel it at this point of time. Only time can tell it, but if you are planning to, please make an appointment well in advance. March is the time right now. You should make an appointment and try to see if you qualify for expedited, and then see how it works out. Emily, on the EAD applications, especially the H4 EAD applications, we have told many times people that, yeah, we applied EAD way more than 6 months before, and we didn't had any problem yet in getting, I mean, let's say, for example, if the H4 EAD is expiring in 1 year from now, we told people to apply, we never had any problem. Have you seen any difference right now?
Yeah, so normally if you're filing a transfer or an amendment, and you can include the H4 and the H4 EAD along with it, even if the EAD is valid for another year or 2 years, so that you can get that longer validity period. But when the EAD is being filed by itself, we have started to see
only one case
situation where there was a request for evidence issued asking, you have a valid EAD that's valid for more than 180 days, why are you filing this application? And they basically give them the option to withdraw. They don't give them any other options.
Right, right.
So
we are, you know, I made some very creative arguments. Most probably I'm going to respond to that, Emily. I may win, I may not win, but my advice to the people is that if you're filing more than 6 months in advance, you have to assume that only, as Emily has pointed out, standalone H4 EAD application. Standalone H4, there is a chance that they may deny your application. I want to warn you guys, because previous to this videos, many times we said we have never seen any denial, but we are now changing our story because of the immigration. There is a chance they may deny it. It will not have any negative consequences on your visa status or anything like that, but they may deny if you file for more than 6 months in advance H-4 EAD. And right now the processing time in California is about 15 months. So I don't understand how the USCIS is planning to do it. You can't apply before 6 months. You apply within 6 months. They're going to take 15 months. I mean, it's ridiculous. We're making some creative arguments. We will update you if this particular case has been approved, not approved. Please tune in every week, so we'll update this kind of information. I got some good questions that came out, Emily. And you based on, in October itself, you said, Emily, that most probably the filing dates are not going to move, and you said that the filing dates mostly will remain the same in November and maybe to December. That is a very maybe, and January also. And the final action dates will move a little bit. That's what you said, and that's what happened. What's the reason why you said that?
Yeah,
because there are a lot of people asking questions about the predictions of why November did not move. What's the story with the December?
Yeah, and that's, if you actually look back to prior years, the filing dates never move except in October. And that's because they're the prediction for this coming fiscal year of what the final action date will be 12 months from now. You can only, the law passed by Congress specifically says you can only file an adjustment of status if a green card is immediately available to you based on your country of birth and category. They interpret immediately available to mean within the next 12 months. So the filing dates chart represent allowing people to file early because the green card may not be available today, but it's immediately available, meaning it should be available at some point over the next 12 months. So that's why the filing date chart only moves generally once a year, and it's the final action dates that slowly move each month so that they meet the filing dates by the end of the fiscal year. So the dates that we're seeing today in the filing dates chart, that's what the final action date chart should look like in September of 2021. That's the prediction based on the filing date chart. That's based on all the data. That's how they decide what the filing dates are. If you look at prior years, the filing dates remained the same every single month. I checked last year, and they stayed the same every single month until maybe June, July, or August, and they only moved a tiny little bit, and we still couldn't use them. The reason nobody really noticed is because we could never use them. So why do you keep looking at the filing date chart? Because if we can't use it. So we just ignore it and go by the final action date chart. So it's actually always been that way. Since 2015, filing dates generally only move once a year, or maybe a little later in the year once they see what the actual demand is of people filing, and it's the final action dates that move to meet what the filing date chart predicted.
And Emily, I want to also add that the filing dates have two organizations, the two government organizations the filing charts are used. One is by the USCIS, which we call immigration. One is Department of State. For the USCIS, Emily is right on it. We can't use it mostly, especially as we go to the end of the year, we mostly cannot use it. When it comes to the Department of State, so it's the filing dates chart that they go with. They don't go with the final action date. We can start processing, the Department of State, we can start processing though. So filing dates is good if you're doing a council processing. It may sometimes be good. It may sometimes be usable with the immigration, like the way we used it in October and we're using in November. But as Emily is pointing out, as we go to the end of the year, most probably the USCIS will say we're not going to accept the filing dates. Many questions coming from YouTube and Facebook is that, what are they going to do with the 944 form, which we already submit? Are they going to reject it? What are they going to they're going to just ignore the 944 form. They're not going to reject it just because you filed it with the 944. They're going to just ignore it. They're not going to do anything about it. A lot of questions are coming out with regards to when would the H4 and when would the EAD application, when would the premium processing will be started on it?
I don't expect that to be anytime soon. It's, I think it depends on which party wins the election, because it's ultimately the Department of Homeland Security that has to implement that by proposing and finalizing a regulation. So if the Trump administration wins, they might take their sweet time to propose that and finalize it. If the Biden administration wins, maybe it'll be faster, but either way, nothing would even start until January with a Biden administration, because he doesn't actually take the presidency until then. So I wouldn't expect anything anytime in the near future.
Questions that come out, somebody's asking for a friend on Facebook is, hey, how many days can I stay without payroll on OPT? Well, there are two different things here. Employment and payroll are different though. In the OPT, optional practical training, that means that if you are obtaining the training, if you're not getting paid, it's okay. This is only in the OPT. This is not in the STEM extension. That's not allowed. You must be paid. You're allowed up to 90 days of unemployment period in the OPT. Now, having said that, any training period where you are obtaining and the employer is giving the training, if you're not getting paid, will be counted as employment period. Even if you're not getting paid, you are going through training, it will be considered to the employment period.
Ram from Facebook wants to know, his H-1B and the spouse's H-4 is valid till January of 2023. If he decides to file a transfer to a new employer, is it necessary to file the H-4 along with it? It's your choice at that point, because obviously the H-4 is already valid for over 2 years, so you could avoid filing for it this time. But then if you don't file it, you have to remember that you're going to have two separate expiration dates. Yours is going to be expiring later than hers, and you want to make sure you don't forget her expiration date, because you'll need to file the H-4 extension at some point. Or she'll have to travel at some point and get the H-4 stamped based on your H-1B approval notice. So it's not mandatory to file it, but a lot of people do file it just so that you have the same expiration date on both applications.
Ravi from YouTube has this question. Can I go with cross-country chargeability and file an I-140 and 485 without dependent? Since it's a cross-country chargeability, that means that you are born in India and your wife is probably born somewhere else. You cannot file the cross-country chargeability without your dependent along with you. No, you cannot file it. You have to file along with your spouse only. Then only you can file the cross-country chargeability.
Sachin from Facebook wants to know what the status of the lawsuit seeking a preliminary injunction on the H-1B wage rule is. And at this point, we're waiting for the judge to decide the preliminary injunction. So no decisions have been made on that yet. I'm sure there's some preliminary filings going on with that, but it might be some more time before we actually get a decision on the preliminary injunction based on that.
Question that came is, have we received any receipt notices for the 485 application? I would say that they are trickling down right now, not much, but they're trickling down, especially the ones that we filed in the first week of October and probably early part of the second week of October. They're trickling right now, not much, but they're trickling a little bit right now.
Vina from YouTube has an approved I-140 and EB-1 with a priority date in October of 2020, so not yet current. Also in the 6th year of H-1B and needing to file an extension in August of 2021. Wants to know if the new H-1B rule for wage levels will be applicable for that extension. As it is at this moment, yes, it does apply to that extension unless we get a preliminary injunction or the regulation is vacated or we have a new president that issues a new regulation to eliminate that regulation. But as of today, yes, that new wage level rule applies to your extension.
Anamika from Facebook has this question. L1 got denied yesterday. I-94 expired. Will there be a grace period right now? I have to sell my home and stuff. Anamika, there is no grace period at all. If your L1 has been denied, I-94 has expired. One thing I want to state the law, I'm not telling you what to do. If a person is unlawfully present in this country for less than 180 days, and they go to their home country, they can apply for they are eligible to apply for the visa. I'm not telling you what to do, but I'm just citing the law. So if I were, I got my H-1B denied or L-1 denied, and my house is there, everything is there, will I just pack my bags and go to airport and then run away? I may not be doing that because I still have 180 days. Now, does it mean that I'm going to stay here for 179 days and leave? No, I won't do that. I'm not advising you anything. I'm just telling what I would do if I were you.
Arun from YouTube is in H-1 status with a valid I-94. Expired visa stamp and passport is expiring soon as well. He wants to know if it's a good idea to apply for the passport renewal before applying for the H-1 renewal. It's really your choice. At the time of filing the H-1 renewal, your passport has to be valid. Even if it's expiring 2 months after you file that application, that's fine. Your extension can still be granted for 3 years, regardless of when your passport expires. Where the passport expiration becomes an issue is if you travel after you got that extension approved. When you come back in on a passport that's expiring in less than 3 years, they will cut your I-94 short at the port of entry, and you'll only be granted stay until your passport expires. So either way is fine, but just make sure that you do get it renewed before you travel next time.
Shiva Kumar from YouTube has this question. I have an H1, can I file a H1B extension from India after the perm is approved? Most probably you have exceeded the 6-year limit and you're planning to go to India, and after I-140 and labor and I-140 is approved, can you apply for the H1B extension while you're in India? The answer is yes, you can. There's nothing wrong with you in applying for H1B. Under this scenario, am I still eligible for the drop box? Good question. Do you see anything? No? Is he eligible for Dropbox? Yes, you are eligible for Dropbox. No reason, And one other thing that I want to mention is that there is a slight change in the Dropbox. Dropbox is working very good. Dropbox is if you have an existing non-immigrant visa like H1 or H4 or B2 visa, and if you're going under the same classification and you're applying for the extension, if your passport visa has expired less than 2 years ago, you're eligible for the drop box. If your first visa, you got it from India, it was granted after 2008, and your passport visa has expired, existing passport visa expired less than 2 years ago, and you have not accrued any unlawful presence in the United States, you are eligible for the drop box. Now, please note, Shivakumar, I told 24 months that your passport visa must have expired within 24 months. This used to be only 12 months before. Now they changed to 24 months. That's the only giveaway that I have seen in the past 6 months from Trump administration, is that instead of 12 months, it's 24 months. If a passport visa is expired, you can apply for the drop box.
Bose from YouTube, him and his wife both are on H-1B and have filed the adjustment of status. And he wants to know if he gets married to the adjustment of status, can his wife still maintain her H-1B? In that situation, yes, because her status is not dependent on yours. If you lose your H-1 status by getting married to your adjustment of status and using that EAD, her H-1 status still continues. It would be different if you were in H-1 status and she was in H-4 status. Then when you lose your status by marrying the adjustment of status, she loses her status.
Questions from Murli. Murli is from YouTube asking, is the new prevailing wage applicable for the amendments and extensions? The answer is yes, they are applicable for amendments and extension. Mohammed from YouTube has this question. Is there any downside in applying green card directly from OPT instead of going through H-1B? I don't see much downfall except that your travel may be limited until you get an advance parole. I don't see any downfall. In fact, I see many plus points for that. A lot of people who are not born in India and China, we do this. It's an expensive process to go through the H-1B. You can circumvent it and go directly from OPT to H-1B. Mimi has this question can I work on the H-4 EAD extension receipt notice? The answer is no, you cannot work on H4 EAD extension receipt notice. You cannot. You have to have the approval.
Santosh from YouTube has a perm that was filed in July of 2020, and the H-1B 6-year limit is ending in February 2021, just around the corner. He wants to know if he's eligible for a 1-year extension beyond February 2021. If your perm is still pending at that point, or your I-140 is not yet approved, you're not eligible for a 1-year extension because your perm was not filed in February of 2020. It was filed after you started your 6th year. So in order to get the 1-year extension of an H-1B, your perm needs to be filed by the end of your 5th year of H-1B. If you filed it in your 6th year, the only way to get an extension beyond the 6-year limit is to get the I-140 approved before your H-1 expires.
SR from YouTube has this question: can a derivatory who is an F1 visa status can apply for a 485 application? Yes, they can. We have a lot of kids who are becoming about 21. I mean, coming near 21, they moved into F1 visa. We did apply for adjustment of status. Not a problem at all. Sid from YouTube has this question: I've applied for the 485 and EAD. Can I apply for H4 EAD also? Will it be any problem? You can apply for H4 EAD while your 485 EAD is pending or approved, it doesn't matter. It's nothing illegal, nothing wrong in applying to different kinds of EADs. You're good, no problem with it.
Suresh from Facebook wants to know if the new wage level changes will impact a perm that's already in process or further H-1B extensions that are filed based on a perm and I-140 approval. So the new prevailing wages do not impact a perm that's already been filed. It only impacts pending prevailing wage requests that were not already done by the time that that rule went into place. And if you already have your LCA certified under the old rule, for your next H-1B extension, that rule, the new rule does not apply, but when you file your next extension or an amendment, the new rule does apply to anything after that.
People are asking, what is the time period for the premium processing? It is 15 calendar days, not working days at this point of time. They haven't changed it yet. They may change it at a later point of time for the premium processing. Question from Gauri Ramesh Satya Prem from Facebook: can H4 visa dependent, can they do volunteering or unpaid internship at university? The answer is, I'm assuming that you don't have any EAD. The answer is no, you cannot. Why? There is a very fine line between volunteer and unpaid volunteer, and a real volunteer and a volunteer with a kind of internship opinion. I'll tell you an example of it. Like Emily, when she was in the law school of first year, she joined our office as a kind of intern in this office. Now that may not be allowed if she was on H4 visa. The reason is that even though she may be volunteering in this office, her intention is probably to get a profit. Either work job in my office, or maybe she's planning to get the experience here and go and join some other office. That is not technically considered as an internship. That is technically not considered as a volunteer job. It's considered as an internship with an intention to gain the knowledge and profit at a later point of time, which is nothing wrong. Now, volunteer jobs are like this. I mean, if she would have gone to a tree planting place in Houston, and then she's planting trees while she's going to law school, does she expect a job in tree planting? Most probably not. She's not going to be a tree planter. So that is allowed. And if she goes to church and she volunteers there, is she trying to become a pastor or something like that? Most probably the answer is no. Most probably the answer is no. So in the cases where she is not expecting a job in the similar lines though, you may be fine in volunteering. But in a university where you're going as an internship though, even if they're not paying, there is a long-term intention for you to actually benefit from that particular experience and use that experience for a gainful employment at a later time. So the answer to you is no.
Ravi from Facebook has a valid visa stamp with a previous employer in an old passport. So he's got a new passport, the visa stamp's in the old passport and has the old employer's name on it. He wants to know if it's safe to travel in that situation or if he needs to get the new visa stamp. So that visa stamp, even though it has your old employer's name on it, it continues to be valid until it actually expires or it gets revoked, which is not a common situation. So you can use a visa from an old employer as long as that visa is still not expired, and enter with your new approval notice with your new employer and provide your new passport with the visa in the old passport. So I don't see any issues with you traveling in that situation.
Question is, H4 EAD receipt notice, the immigration received on October 12th, did not receive the receipt notice yet. Is that something to be concerned about? No, we are noticing that very commonly that it's taking a long period of time for getting the receipt notices. A month period seems to be a normal nowadays to get a receipt notice.
Teju from YouTube wants to know if the spillover green cards from family-based can go back to family-based after the ban is lifted. No, the current operation of the law says once the fiscal year ends, any leftover family-based green cards from that fiscal year carry over to the next fiscal year for employment-based. So by operation of the current law, just because they're lifting the ban, it doesn't mean those green cards go back. It would take an act of Congress for that to happen. There is a provision in, I think, the HEROES Act or one of the coronavirus relief bills that would modify and make sure that those green cards...
But I think so they might still face a problem in the Senate.
Right. I'm not suggesting that those bills are likely to pass as is, but there is, a potential.
One question here is, Masood from YouTube has this question. He got his green card approved, married to a green card holder, and should the green card be valid for 10 years or it should be only valid for 2 years? Since your marriage to the green card holder is less than 2 years though, it should be a conditional resident for you. If it was more than 2 years, then you should get a 10-year green card. Okay, repeated questions. On the visa bulletin delay though, especially in the November visa bulletin delay was different political reasons, nothing to do with the immigration as such though. But if you look into the past 6 months though, the visa bulletin is coming at 20th. If you go previous years and all those things, you will normally get between 8th and 13th though. Nowadays it's getting to 20th, but coming in 26th is really unusual, and that came because of political reasons, something to do with China and Hong Kong, nothing related to the employment-based immigration, especially for Indian nationals.
Chitrajan from Facebook has a child whose H4 extension is still pending because of these long processing times, and he's planning on changing employers. He wants to know if he should apply for another I-539 for his dependents. You really have the choice. The I-539 processing is based on you continuing to maintain H-1B status, even if that is continued with a new employer. So it's not mandatory to do it, but we do from time to time to see a weird situation where you filed your transfer, you didn't file another H-4 extension, and your old employer withdraws your H-1B petition. Every once in a while, that triggers an issue with that pending H-4, where they think that because your H-1 was denied, you must not be maintaining H-1 status, and they actually deny the H-4. That's an improper denial, because if they would have looked in their system, they would have seen you're maintaining your H-1 status with another employer based on the new approval or pending receipt notice. But that does happen from time to time. So for that reason, you may want to file it just to avoid that potential situation.
Questions that are coming out with regards to the I-140 downgrade applications. Will the new prevailing wages be effective especially for the downgrade applications that were filed in the month of October? The answer is no, they are not applicable. The one reason is labor certification is already approved. So we're not revisiting the labor certification, we're only revisiting the I-140. The prevailing wage and all those things are already done long time ago, before 2015. So the new prevailing wages are not applicable for the downgrade applications that we filed last month and filing this month.
Shivani from YouTube is on H-1B and working from home and is changing her home address and wants to know if an amendment or a new LCA is necessary for that. In her situation, she's moving within the same MSA. So a work location change, which is technically her home address, where it's in the same MSA, it does not require an amendment, it does not require a new LCA. That LCA covers your new work location as long as it's within the same MSA. If you are working from home and move to a different MSA, an amendment would be required before that move can happen. Ashwin from Facebook wants to know, with the new H-1B rule, if I'm working in software but have a mechanical engineering degree, will it be a problem? Yes, that's exactly what they're targeting. But if you have years of experience in software, you can get an education plus experience evaluation that combines to give you the equivalent of a computer science degree, then you're fine. So in your situation, you mentioned, I'm guessing, 7+ years of experience. So for your next extension, I would generally be requesting, if I was, in our office, we would be obtaining an education plus experience evaluation and submitting that at the time of filing to avoid that kind of problem.
Did you answer about the H-1B or I-140, Emily? The answer
that was H-1B related.
Emily, the question mainly pops up is the downgrade application, especially if they have a degrees in the mechanical engineering, and then even though in the labor certification we specified that engineering or software, do you expect any problem in the I-140 for the downgrade applications that we filed last month?
No, because the I-140, you're not proving it's a specialty occupation. That's a completely separate criteria. The I-140, all you have to prove is that you meet the education requirements set out in the labor. So if the labor certification allows for an engineering degree, your engineering degree qualifies. If then you're filing your H-1, which has to qualify as a specialty occupation, then you would need the education plus experience evaluation.
Arpit from YouTube has this question. Can I self-file EB-1A? At the same time, can my company file an EB-2 I-140 application? Yes, you can. Absolutely no problem. Question from Manogna. After submitting 485, how long it's taking to get a receipt notice? I would say that it's taking a month, anywhere between 20 days to 45 days is the typical period to get a receipt notice.
Raghavendra from Facebook wants to know if the new wage rule applies to an amendment. So yes, if you are filing that amendment and need a new LCA to go with it, the new wage rule does apply to that amendment filing. If you're filing the amendment with the old LCA that remains valid, then the new wage rule does not apply.
Are there any restrictions for the H-4 visa to apply for stamping in India right now if the main applicant is here? No, they can still apply. The only problem is the visa appointment dates are backlogged all the way to March of 2021. Vijay from Facebook has this question. Does the 240-day rule apply for the H-4 extension? Vijay, the 240-day rule is not applicable for H-4 extension. If the extension is pending, they can stay in United States until the H-4 is adjudicated. Absolutely no problem. I just want to remind you, Vijay, one other thing is that when it is applicable for the H-1s also, after the 240 days when you file for an extension, remember that the 240-day rule is not applicable for amendment plus extension. It's not applicable. It's not applicable for the transfer. It's only applicable for the extensions. It's not applicable for the transfer only. Now, this after 240 days that your I-94 expires, though, you can still stay in the country, but you cannot work. That's the rule for the 240 days. In your spouse case, though, since she is applying for H4, she can stay in the country even after 40 days. She's perfectly good.
Fanny from Facebook wants to know if there will be any RFE or possible denial if the prevailing wage level is downgraded due to the new wage level. Yes, there is that possibility. You have to understand that the wage level is not determined by your salary. It's determined by what are the job duties, what are the normal education and experience for that job? Are there any special skills involved in your job? Is there any supervisory requirement to your job? So the wage level has nothing to do with what your salary is. You have to determine the wage level based on what the job requires. So if you're doing the exact same job, the wage level should not go down because you already selected a particular wage level based on the job duties. If you're doing the same job, you can't now say, oh, it's a level 2 job when before it was a level 3 job because nothing changed.
But
now, if there's a different job, your job duties have changed, or the requirements for the position are different now, they're lower, or you don't have those supervisory requirements anymore, then potentially. But you can expect a possible RFE because I do think USCIS is going to be looking from one petition to the next when you're filing an extension to see if that kind of change is being made.
Srikanth has this question. If the I-485 is pending, no green card has been given, no EAD yet, and if the H-1B expires, can I stay legally in United States? If you are the main applicant, the answer is male applicants are dependent. You can stay in United States, even if the H-1B expires, even if your EAD is not granted, as long as the 485 is pending. Now, here's the thing. One thing you're doing here is that you're getting married to the 485. And if you don't know what getting married to 485, I want you to watch the past 3 videos that we have released in the past 3 weeks. You will understand what getting married to 485 is.
Speaking of getting married to the 485, Praveen has a question about that. He wants to know if we get married to the EB3 and at the later stage the EB2 final action date is actually better, what's the process to move back to EB2? Is it possible? It's possible, but it's not practical or easy to do because you can't, in order to file an EB2 now, you have to file another 485 with your EB2 I-140 approval notice. To be eligible to file another 485, you have to be in a non-immigrant status. Being in adjustment of status, meaning you're married to your adjustment of status, you're not eligible to file another adjustment of status. You have to be maintaining an underlying H1 or L1 or H4 or L2 status. So that means once you marry the EB3 adjustment of status, how do you get back into a non-immigrant status? The only way to do it is to exit the country. Your employer has to file another H-1B petition for you, get it approved under all these new regulations and requirements. Then you have to exit. You have to get a visa stamp.
Looks like a divorce to me.
Yeah, and then you come back and then you can file the adjustment of status, assuming you actually can get an appointment and get the visa stamp. Is not a very practical option.
Emily, there's a lot of presumption with the people that somewhere EB2 is better than EB3. When you look into the Chinese nationals, it doesn't look like that. Somewhere for Indian nationals, it's just incorporated in them. EB2 is better in getting the green card.
Well, yeah, I mean, over the last 10 years, everybody's upgraded from EB3 to EB2 as they gained their 5 years of experience, as they got a master's degree on the side and all of that, because EB2 was always faster. So everyone, over 10 years.
But not in the past 2 years, though.
Right.
It's been going flip-flopping, though.
Right, yeah.
Not in the 2 years, and if I look into the Chinese nationals also, it's flip-flopping. It's been flip-flopping for past 7-8 years. So even if the EB2 becomes current for you in EB3, would I jump immediately to EB2, leaving the EB3 and leaving all the dates and the time processing? I'm not sure I would do that.
Mm-hmm.
I think so that even if the EB2 becomes current, it's just like the way LA traffic, I mean, it's the worst traffic to go through. I mean, you stay in one line, the other line moves, you go to the other line, guess what? That line stops and this line moves. So it may be worth, and especially when you move from one line to another line, you are you're at caboose. You know what caboose means? You go to the end of the line. The reason why I tell end of the line is there is also processing period time that is there. So the processing period time varies a lot. And so the way that you're telling is to file one more 485 application. Remember that 485 application processing time is anywhere between 12 months to 45 months right now. So then you're going to the caboose, you're going to end of the line. It's not like at the LA traffic where you move from this line to this line. When you move from this line to this line, you get to the end. You're caboose. So you may have to evaluate a lot of things when you're trying to move to EB3 to EB2. You may have to evaluate very closely to see, is it worth, is it not worth?
Srinath from Facebook wants to know, if I continue using my H1 and my wife uses the 485 EAD, does it automatically marry me to the 485 EAD? No, it does not, because your status is not dependent on her. It's the other way around. So you can continue to maintain H1 status even if your wife uses the EAD. If you are in H4 status and your wife uses the EAD because she was in H1, that's where you would also get married to the adjustment of status.
One other thing I may want to discuss with you, Emily, I may want to discuss about changing what we told 4 or 5 weeks before, or 10 weeks before, or 2 years before. We always advise that, hey, you don't need to file an EB3 application well in advance, though. We've been predicting that the EB3 may move forward. We have released a video in 2018, 2019, and about 3 months before, somewhere in August or so, we released another video of downgrading from EB3 to EB2. We recommended at that point of time, you don't have to do the downgrade before the priority date became current. Are you willing to change that right now?
I'm not willing to make a change to that yet. I think that, so let's go back and say, what if I am starting my perm process now?
Okay, you start the perm process right now.
Would I pick EB2 or EB3? I would still pick EB2 so that when I get to the I-140, I have the choice. I can go EB2 or EB3. If you file your perm EB3 based, you're stuck in EB3. You can't file an EB3 perm in EB2. Now, when I get my perm approved, I might ask my employer, hey, can you file 2 I-140s?
So you can, wait, you can file 2 I-140s at the same time?
Yes.
Okay, EB2 and EB3.
Exactly. So that's what I would be looking at doing if these dates keep flip-flopping or eventually are the same. File it in both.
So there are 2 things here, Emily. One person is the person who is filing right now. What about the persons who are very edge, like maybe 2015, 2016? What do you say about them? Because I'm more inclined, and they're already, I-140 is already approved. Would you tell them to file an EB3 right now?
I think I would want to see more movement in the dates.
I
think it's too
disagree.
early.
I disagree with Emily on that particular thing. I have a different opinion. I used to have the same opinion though, but now I'm trying to change the opinion a little bit. If your filing date is, if your priority date is before 2017 though, I may, if my priority date is before January of 2017, I may consider filing an EB3 right now. Remember, by filing an EB3 downgrade application, you are not doing away with your EB2. The EB2 still exists. So now you have 2, one this, one that. You can use whichever one you want to if you have EB2 and EB3. So I may be inclined, if I were having before 2017. As Emily pointed out, even if you're filing fresh, you can have both applications filed at the same time. You can do that even if you have something in 2016 and 2017. Maybe I'll just file an I-140 application, keep it ready to see which one goes faster.
Praveen from Facebook has an H-1B petition that's approved till 2022, and he wants to know if he goes for stamping, will the new wage rule impact stamping? No, it will not. So the old rules still apply to any petition that's already approved. They're not looking back at the wages to see if you meet the new wages. It will be on your extension where that will apply.
Thanks for coming to an end. I just want to give some things, guys. It's very glad that we're able to help you guys, and believe me, it's helpful for us too. The information that you send to us is helpful to keep us on the toes and be educated about what's going on in it. The feedback that you give is very important for us. We may want you to request you, and if you want to have certain topics to be covered. We're willing to cover those topics in 5 minutes or 10 minutes videos separately. You can post them in your Facebook request or the YouTube request. We will look into those things and may want to present those things separately, not just as a question and answer. Anything else, Emily?
I think that's about it. Thanks for joining us. We'll be back next Tuesday.
Thank you.